My name is Jason Auer. I am the Fair Housing Project Director at Legal Aid of Arkansas. I've been at Legal Aid for roughly 13 years now, doing a lot of housing and landlord-tenant law. Currently, I run our fair housing program and deal with housing discrimination cases. So we're going to be talking about unlawful detainer today, or evictions in Arkansas. Try to give you guys as much information as possible here through the next hour on unlawful detainer. I've also got one of our staff attorneys, Jenny Ashcraft, here with us. Jenny is going to be helping us out in the chat. Got somebody saying they can't hear. Can you guys hear me? All right. Okay, good. Seems like other people can hear. All right. So we are going to be moving through a lot of material fairly quickly. 1 second. All right, we've got our agenda for today's CLE is going to be we're going to be going over a brief overview of eviction in Arkansas. We're going to start by looking at the different eviction statutes and eviction-like statutes that are available to landlords here in Arkansas. Then we're going to move into some specifics on the unlawful detainer statute, which is the most commonly used civil eviction statute here in the state. We'll then talk about some special issues that come up in eviction cases, mostly focusing on federally subsidized housing and fair housing or housing discrimination. And then we'll end by taking a look at the other half of the unlawful detainer statute, which is the forcible entry and detainer statute. And that is where essentially someone who is in possession, a tenant in most cases, can bring a case against a landlord who illegally does something to dispossess them of their property. All right. So first thing we're going to do is we're going to kind of look at the galaxy of eviction laws in Arkansas. There's not just one, although unlawful detainer is the most common one. It is not the only one. There are a few others as well. The first one that you need to know about is the eviction statute that is in the Arkansas Residential Landlord Tenant Act. The Residential Landlord Tenant Act was passed in 2007, and it was based on the Uniform Residential Landlord Tenant Act. So this was Arkansas's version of a uniform law. It had heavy modifications, I would say, from the uniform law. A lot of the tenant protections in the Arkansas residential, or that were in the Uniform Act, were taken out in the Arkansas version. And an eviction statute that is not in the uniform law was added on. And that is at 1817-901. That's where that eviction statute begins. It is intended to be an eviction statute that can be used in Arkansas state district courts. However, the Supreme Court has never extended jurisdiction to the district courts to hear eviction actions. So the jurisdictional authorization to, or the jurisdiction of the district courts to actually hear these cases is somewhat dubious, and most district courts don't hear them, although there are a few around the state that do hear them. It works in some ways similar to unlawful detainer, but it also has a little bit different requirements as well. It does have an interesting eviction notice requirement where it requires a 14-day notice with an opportunity to cure any violation that's not non-payment of rent. Non-payment of rent under the statute doesn't require an eviction notice at all. It simply says that if you don't pay rent for 5 days, that essentially, or you're 5 days late on your rent, that is your eviction notice. So that's the Arkansas Residential Landlord Tenant Act eviction. Like I said, it's not heavily used in Arkansas due to some jurisdictional problems and some due process problems, but it is still on the books and it is used in certain counties. Next statute is our failure to vacate statute. This is also known as criminal eviction. It's found at Arkansas Code Annotated 1816-101 of the Arkansas Code. So this is essentially a misdemeanor criminal statute. Arkansas is the only state in the nation to have a statute like this. I think there was one in Florida that was repealed in the 1930s that was similar, but that's the only other one we ever found that was anything like what goes on in Arkansas. So what this is it's a misdemeanor criminal penalty for non-payment of rent. How it works is landlord makes or gives a 10-day notice to their tenant saying that they're behind on rent. If the tenant does not either vacate or pay rent within that 10 days, then the landlord can go back and make an affidavit with the prosecuting attorney, either in the city or the county. And at that point, a misdemeanor criminal charge is filed. The statute has been changed or amended and amended back over the years. At one point, there was an escalation to a Class B misdemeanor in this law. That part has been taken out by the legislature a few years ago. And so now, I mean, it's essentially a simple violation. There is a $1 to $25 a day fine for any time that the tenant stays in the unit or in the apartment past the 10-day notice. So if they stay in for 5 days, they can be fined $1 to $25 a day for each of those 5 days that they stayed beyond that. So in a way, it kind of punishes tenants for maintaining a defense, or at least it can have that chilling effect, because the longer they maintain a defense, the larger their fine can end up being. Once again, this is not heavily used in Arkansas at this point. There was a lot of litigation on the statute back in the 2015 to 2017 range, and a lot of counties stopped using it. A lot of prosecutors didn't like using it in the first place, but it is still used in a few counties, and it's used fairly heavily in a couple counties, particularly in Garland County. Ejectment. Ejectment is it's not actually an eviction statute. It's a statute where if title to property is being contested, then this is the proper action. The unlawful detainer statute actually specifically says it does not deal with title to property. It was put in the Arkansas Code in order to be a summary process for situations where title to the property was not at issue, just possession of the property. If there is a good faith dispute as to who actually owns the property, the person in possession or the person wanting possession, then an action for ejectment is the correct cause of action. That is not a summary process, and it involves pleading color of title to the property along with the initial complaint and the answer, so that that issue can be adjudicated. We've also got writs of assistance in Arkansas. Those are typically tied to foreclosure actions. So if someone falls behind on their mortgage and the bank institutes a foreclosure proceeding and ends up selling the house, and the original owner of the property, or the person who got foreclosed on, is still in there, the bank in most cases, or the new owner, can ask for a writ of assistance in removing that property or that person from that foreclosed property. All right, so those were different ways people can get dispossessed of their property. Now we're going to move into unlawful detainer specifically. And you can see it's at 1860, 301 through 312 of the Arkansas Code. And this, like I said, is the most common method of eviction in Arkansas. It is a summary procedure, civil remedy for property owners that in most cases, it's a landlord-tenant relationship where they seek to remove a tenant from the property for some type of breach of the lease. But it doesn't necessarily require a landlord-tenant relationship. One of the most important things to know about it is a bifurcated process. It requires two separate hearings, and we'll talk about how exactly those come up here in just a second. So the statute specifically gives some actions that constitute unlawful detainer. The first of which is a holdover tenancy. A holdover tenancy is where a tenant enters in possession um, pursuant to a lease agreement, either a written or oral lease agreement, and stays beyond the end of that lease agreement. At that point, they're considered to be a holdover tenant, and they are going to be subject to unlawful detainer unless a new lease is either negotiated or otherwise agreed to. Um, Second action constituting unlawful detainer is where someone peaceably obtains possession and unwillfully and unlawfully remains after notice to vacate is given in writing. This is one of the most common ways that we see unlawful detainers coming up. This is essentially a breach of a lease agreement. So a tenant lawfully gains possession of the property and then does something to breach the agreement that they have with their landlord. The landlord then has to give them a written notice to vacate. There's not really any requirements or guidance on what that notice to vacate has to look like or how many days it needs to be, other than it needs to be in writing. But that's just your common breach of the lease situation. Your third one is going to be refusal to pay rent. So if it's a tenancy and there has been some rent agreed to, then after a 3-day notice in writing for non-payment of rent, landlord can institute an unlawful detainer action. That one does have a very specific notice requirement. It says 3 days. For a general breach of a lease that's not non-payment of rent, it's a little more ambiguous. Failure to maintain property in a safe, healthy, and habitable condition. So if someone is, or if a tenant is maintaining property in a way that's not safe or not healthy or not habitable, causing a lot of destruction of the property, that will also constitute unlawful detainer. Typically, there's language in the lease regarding these things, so that could be maintained either under the notice to vacate provision or on its own under this specific statutory language. And then the final one is if someone in possession causes or permits the property to become a common nuisance or a public nuisance subject to abatement, and there are specific statutory definitions for those. All right, notice requirements for a holdover tenancy. So once again, a holdover tenancy is where you've had an agreed lease term and the tenant has, without permission, stayed beyond that lease term. How does that happen? Well, typically, there has to be some communication at the end of a lease term about whether it's going to be extended or not. If it's a month-to-month lease, what the Arkansas Residential Landlord Tenant Act requires is that the party seeking to terminate the month-to-month lease give at least 30 days notice. That can come from either the landlord or the tenant. So if either of those parties give that 30-day notice, then the lease will terminate on the first of the next month. And at that point, if the tenant stays, they are a holdover tenant. It works the same for tenancies that are less than 30 days. The statute specifically talks about a week-to-week tenancy too. That one's the same, works the same way, except it's a 7-day notice. Terminations of other lease agreements are going to depend upon the language in the lease. So if you've got a 1-year lease, for example, that's typically going to have some language in it about how that lease terminates and what the notice requirements are in order to terminate that lease. If there is no language in there, then it simply is going to terminate on the date that it ends. So if it's a 1-year lease, 1 year from the date it began, it will end. All right, notice requirements for non-payment and other breaches of the lease. Unlawful detainer statute is very clear as to non-payment of rent, that a 3-day written notice is required. The unlawful detainer statute is much less clear when you're talking about some other breach of the lease. So if you're talking about a breach of lease based on habitable conditions or a breach of the lease based on too many people living there, or any other breach of the lease you can think of that would trigger an unlawful detainer case, The law says that the landlord does have to notify the tenant in writing of that breach and give them notice to vacate. But it doesn't specify much else than that. It doesn't specify how many days the notice needs to be, and it doesn't really specify what the notice needs to have in it. The Arkansas Residential Landlord Tenant Act, which, like I said, was passed in 2007, does speak to this a little bit. And what it says is that if there is some non-compliance with the rental agreement, the landlord, and I've got it in bold there, may deliver a written notice to the tenant specifying the acts or omissions constituting the non-compliance, and that the rental agreement will terminate upon a date not less than 14 days after the receipt of the notice if the non-compliance is not remedied. So what we call this is an opportunity to cure. So what the landlord's supposed to do is notify the tenant of the alleged violation of the lease and give them 14 days to cure. So if it's a habitability issue, that's 14 days to clean it up. If it's a unauthorized occupant issue, that's 14 days to get rid of that unauthorized occupant. But in the helpful way that this was written, it says the landlord may deliver a written notice. So it doesn't say shall deliver a written notice. So I don't know. I don't know what to make of a statute that says you may do something or may not do it. That's not very strong language. So, but that's what it says. All right. So that's a little bit on eviction notices. The process for an unlawful detainer always is going to start though with a notice to vacate. It's either going to be that 3-day notice to vacate for non-payment of rent, or it's going to be the other written notice to vacate for another lease violation. The notice has to be given in such a way as is reasonably calculated to get to the tenant. There's U.S. Supreme Court precedent on that. That's a due process issue. You have to, as the landlord, give the notice to the tenant in some way that you're reasonably sure they're going to get it. Typically, that's going to be personal delivery, but it could also come through the mail. We've seen a lot of notices by text messages and email. And if those are ways that you're communicating with your tenants as a landlord, that's probably okay. That seems like it's written notice to me. If you turn the notice into a paper airplane and sail it over somebody's house, that's probably not going to be reasonably calculated to get to the tenant. The tenant does not vacate by the end of the notice period, so that'd be after the 3 days. Then at that point, the unlawful detainer case is right to file in circuit court. If the landlord either doesn't give the notice or files the unlawful detainer case before the notice period is up, then the case is defective and subject to dismissal. Unlawful detainer. So how does the lawsuit work? Okay, it's going to start with a summons, and the summons is going to be the typical civil court summons with one exception, and that is that the summons needs to draw attention to or identify the notice of intent to issue writ of possession, which is an extra document that talks about the specific procedure of an unlawful detainer case. And that's extremely important because the unlawful detainer is going to proceed a bit differently than your normal civil case. So, and let's see, we'll talk about that in just a second. Along with the summons, you're going to get a complaint and unlawful detainer. That's going to look like a typical civil complaint. That's going to lay out the allegations against the tenant or other person in possession. They're also going to get that notice of intention to issue a writ of possession. That's an extra document that's got specific statutory language in it. And what that is going to talk about is the fact that there is a summary remedy for possession in an unlawful detainer case. So typically in a civil case, of course, you've got 30 days under the rules of civil procedure to respond to a complaint. That's not entirely true in an unlawful detainer case. In an unlawful detainer case, you're going to have 5 days to object to the issuance of a writ of possession. Writ of possession is the court order that allows the sheriff to come out and forcibly evict someone. If a tenant does not file a written objection to that issuance of a writ of possession within 5 days, not counting Sundays and legal holidays, then the court can go ahead and issue the writ of possession basically before that statutory or before the 30 days runs that would normally be available under the rules of civil procedure. So you get your summons, you got your complaint, you've got your notice of intention to issue a writ of possession. There also has to be, along with the complaint, an affidavit signed by the landlord or other credible person stating that basically stating that the allegations are true and that the plaintiff is entitled to possession of the property. And if that affidavit is not present, then the complaint is defective and subject to dismissal as well. So you need a summons, you need a complaint, you need the notice of intent to issue writ of possession, you need the affidavit signed by the landlord or other credible person. And then in order to comply with the rules of civil procedure, specifically Rule 10D, you're going to need any documents on which you're basing the unlawful detainer. Typically, that's going to be the lease for the property and the eviction notice, because those are both going to be required to show the breach of the lease and the fact that you've properly noticed the tenant. Summons for unlawful detainer can be pretty confusing. 1863-07 states that the customary summons shall be served on a defendant and that the plaintiff shall also issue a notice of intention to issue a writ of possession. And that has to be set out on the summons. So as you can see, this is your typical civil summons, and it's got your typical civil language about that you have to file an answer within 30 days or 60 days if you're incarcerated. But then if you go down and look towards the bottom of that summons where it says additional notices included, in little writing there, it says notice of intent. So this is one we actually pulled off one of our unlawful detainer cases recently just to show you guys what this can look like. So tenant will read that, they'll see that I've got 30 days to answer this. And then if they don't look through it any more than that very quickly, they'll miss that notice of intent. And what that notice of intent is pointing to is this next document here. And I know the writing is a little bit blurry there, but that is specific statutory language from the statute that talks about the fact that the tenant has 5 days to object to the issuance of a writ of possession, and that if they don't file that objection with the circuit clerk within 5 days, then the court can go ahead and issue a writ of possession without a hearing. So that is very important language to read, and you wouldn't necessarily get that from the summons as a tenant if you're just looking at that. How does the lawsuit work? Well, once the tenant is served, and they are going to be served according to Rule 4 of the Rules of Civil Procedure, just like any other lawsuit. So that can come most commonly through a process server, but there are other ways to serve people in Arkansas under Rule 4. So they get served. Once they are served, they have 5 days to file that written objection with the circuit clerk. Written objection just has to state some basis of why the tenant is objecting to the unlawful detainer case. And they've got 5 days to file that. That 5 days does not count Sundays or legal holidays, but it does count Saturdays. So watch out for that because you can lose a day. So Saturdays count against the 5 days, even though you can't typically file a response on a Saturday with the clerk's office. Especially if you are a pro se litigant. There's no more registry deposit requirement. So until a couple of years ago, the unlawful detainer statute required a tenant that wanted to contest possession to deposit the money that the landlord alleged that was owed into the registry of the court in order to be able to even make an objection to the writ of possession. That is no longer a requirement because that had serious due process concerns. Basically, that was a pay to play, pay to make a defense provision that was in there. That has been taken out. Once if the tenant does not object to the issuance of the writ of possession within that 5 days, then the court can go ahead and issue the writ of possession without a hearing. Statute used to say that the clerk was able to do that. So we used to see that clerks would sign off on these writs of possessions without even showing them to the judge. That has been clarified as well in recent years. It now does have to be a judge that issues the writ of possession, but we still occasionally will see clerks doing this. That's a relatively new addition to the statute just in the last couple of years. It does have to be a judge now that signs off on the writ of possession. If the tenant does file an objection stating a basis um, for objecting to the issuance of the writ of possession, then the matter is set for a hearing before a circuit judge. And then the tenant still has their 30 days to file a full answer. So like I said, the objection just has to state that they're objecting to the writ of possession and provide some legal basis for that objection. The tenant then can still file a regular civil answer within the 30 days allowed. That's typically going to deal with other stuff like any damages that the landlord, monetary damages, I mean, that the landlord may be requesting in addition to possession of the property. Unlawful detainer hearing is going to be bifurcated. The first hearing is going to be on possession alone. It's called a possession hearing of all things. And what the court is looking at the possession hearing is just possession of the property. It's not dealing with damages. It's not making any ruling as towards money. It's just looking at whether to grant the landlord summary possession. And it will do that if it finds that the landlord is likely to win on the merits. So it's kind of like a temporary restraining order hearing, but it's got a similar standard with the likelihood of success on the merits, but it may be a little bit lower of a standard than what you would require under a TRO. It just has to show that the landlord's likely to win on the merits. If that's the case, the court will go ahead and issue the writ of possession. If the tenant loses possession at that possession hearing and they still want to maintain possession because they think they have some defense that they can make at the later full trial on the case, they are allowed to request that the court post security. Up until a couple of years ago, this just said the security just said security in an amount to be determined by the court. The legislature, General Assembly went back a couple of years ago and clarified that a little bit. And now the security is that language in parentheses there, not less than the amount of any delinquent rent and rent to accrue while the defendant is allowed to retain possession of the premises. So this is where the court has decided that, okay, the landlord is likely to win on the merit, but the tenant says, well, wait, I still want to go to a final hearing and have my day in court. And I want to be able to maintain possession until the final hearing. They can post the security. They can request that the court set security. Many landlords non-suit the case after they get the writ of possession. We see this a lot. So a lot of times landlords are just looking for possession of the property. So after that possession hearing or after the tenant defaults on the 5-day requirement, they will simply dismiss the case. Although they absolutely don't have to, they can put on evidence at a later hearing of whatever damages they think they owe. That's typically going to be back rent or some type of damage to the property, physical damage. Final hearing on damages comes later. That's going to be set on the regular court docket. Either party can request a jury trial. It is a full civil trial that is contemplated under the statute for that second hearing. Damages, if the landlord wins, they can get their actual damages. So like I said, that's back rent, that's structural damage to the property, that's holes in the wall, that's torn up carpets, anything like that. There's also liquidated damages under the statute, which is essentially a statutory fine in the amount of 1 month's rent for a residential case and up to 3 months rent if it is a commercial unlawful detainer. If it's a commercial landlord tenant situation, so like a store or something like that. We don't deal with any of those at legal aid, but we do deal with a ton of residential cases. And then court costs they can get. So that's going to be filing and service fees. If the tenant wins at the final hearing, tenant can get damages if they were wrongfully dispossessed earlier. So if we'll talk about attorney's fees in just a second, Paige. So if the tenant wins, they can get damages for being wrongfully dispossessed. So that could be moving expenses, that could be the cost of temporary housing while they were dispossessed, if they had to stay in a hotel, something like that. And they can also, in certain cases, and this is very rare, get what's called a writ of restitution, which is the opposite of a writ of possession. It actually allows the tenant to get back possession of the property if the court finds that they were wrongfully dispossessed. And like I said, these cases can be, the final hearing can be tried to a jury if either party wants that. All right. If a writ of possession is issued, that will be signed by the judge. It will go to, so I think I may have missed a slide. Oh, sorry. All right. If the writ of possession is issued, once again, the writ of possession is the court order that allows law enforcement, typically the county sheriff, to dispossess the person of their property, the tenant. The sheriff will go out and get the writ from the judge. Typically, the attorney gives it to the sheriff, the plaintiff's attorney, I mean. And the sheriff will then go out and serve the tenant. The writ gives the tenant 24 hours to vacate. So we get a lot of calls saying from people saying, hey, I just got a 24-hour eviction notice. Typically, that's not the eviction notice, that's the writ being served. And and so at that point, the tenant will have 24 hours to remove their possessions and their person from the property. If they don't do that, then the sheriff can come back and forcibly remove the tenant from the property. Any possessions of the tenant are then, that the tenant leaves there, are supposed to be locked up and stored. That's specific language in the unlawful detainer statute. It's going to be the landlord's responsibility to lock up those possessions in a safe place. They are not to be thrown away. They're not to be left on the curb in the rain. They're not to be given to other tenants. A lot of that kind of thing does happen. Supposed to be securely locked up pending disposition of the case after the final hearing. If there's a judgment after at the end of that final hearing, the possessions can then be sold to satisfy that final judgment. If there's no final judgment, or if there's a judgment for the tenant, then those possessions are, of course, returned to the tenant. I will say there is a law floating around the General Assembly right now to further clarify what happens to possessions that remain on the property after a writ of possession. This law could be changing. I have no idea what the prospects of that law are to pass, but just be aware that this law may change a bit. Attorney's fees, we just had a question about that. So in general, in Arkansas, attorney's fees are only recovered if they are authorized by statute or court rule. The unlawful detainer statute itself does not specifically authorize attorney's fees. Got a couple cases cited there that say that. There was just one that came out late last year that made the same point. So this law has not changed. So unless there is some other cause of action that is brought that authorizes attorney's fees, courts should not be awarding attorney's fees to either side in an unlawful detainer case. There is, specific statutory authorization for breach of contract, for example, so a court can maybe use that if the landlord's attorney pleads breach of contract, but an unlawful detainer case itself is not going to trigger any fee shifting. And I will point out, not all unlawful detainer cases are necessarily even based on a breach of contract. So you can have situations where someone is possessing property, but there was never any contract with the owner. Classic example would be like an estate issue where someone was living in property. We had a case where a woman was living with her boyfriend in his property. He died, and then his family didn't want her there anymore, so they file an unlawful detainer case to make her leave. There's obviously no contract between her and them, so in that case, there's really no way to claim attorney's fees. All right, so that was an overview of how the unlawful detainer statute works. We're now going to move into some special issues in eviction and unlawful detainer, subsidized housing, and housing discrimination. Unlawful detainer and subsidized housing. The point I really want to make here is that it's a little more complicated than just a private landlord-tenant relationship. So what is subsidized housing? That's going to be housing that is subsidized by some type of government funding. Classic examples would be public housing. So public housing is housing that is owned by a local housing authority, which is a governmental entity like the Little Rock Housing Authority or the Fayetteville Housing Authority. They own property and they lease that to low-income tenants. Um, Section 8 vouchers, those are your housing choice vouchers that low-income individuals are given by a housing authority and then they go rent in the private market. Project-based Section 8 is uh, basically housing projects that are directly subsidized by HUD, by the federal government. Multifamily properties, similar thing. There are rural development properties. There's low-income housing tax credit properties, which is an IRS tax subsidy to build property for low-income individuals. The thing to know about all of these is that they all have federal regulatory schemes that go with them. And most of those deal with when a lease can be terminated, what type of notice is required, and how exactly an eviction is supposed to proceed. We've got this Arkansas Court of Appeals case, Dial versus Star City Public Housing Authority. And what that does is say that if the publicly funded housing project does not strictly comply with the regulatory scheme that it is operating under, then it cannot maintain an action in unlawful detainer. So if you're defending these cases, subsidized housing cases have a lot more procedural rules that you can use as a defense. If you are a landlord's attorney and you are representing subsidized housing complexes, then you really need to understand what federal regulatory scheme that particular complex is operating under, and you need to strictly comply not only with the Arkansas law for unlawful detainer, but the federal regulations, which can require things such as stating good cause for any eviction, very specific notice requirements and timelines, and requirements as to what's in the eviction notice. Some programs require either an informal conference with the housing provider before an eviction can be initiated, or in the case of public housing, there actually has to be a formal grievance hearing, or at least have one offered. So be aware of all of that if your housing project is receiving direct federal subsidies from the government. Fair housing. So this is what I do on a daily basis. This is housing discrimination. Um, and the important thing to know about this is, as it relates to eviction anyway, is that a landlord cannot evict someone if any part of that eviction decision is influenced by a person's protected class. That is going to be prohibited by both the Federal Fair Housing Act, which is the federal law passed by Congress in 1968 that prohibits housing discrimination in this country. And there's also an Arkansas Fair Housing Act, which contains the same basic protections and prohibitions as the federal law. And that was passed in Arkansas in 2001, I believe. So there's both state and federal law saying that, among other things, you cannot evict somebody based on the 7 protected classes, which are race, characteristics associated with someone's race, color. Color involves skin tone and can take place actually within the same biological race. Religion, which is religious observances, practices, or beliefs. National origin, which is the country individuals are from, or physical or linguistic or cultural characteristics that are associated with being from a specific country. Sex, which is biological sex. Can't evict somebody because they're a man or because they're a woman, or because they have refused your sexual advances as a landlord. That's a sexual harassment is included. So we've had cases like that before. Familial status, can't evict somebody because they have children under the age of 18. So the individuals have kids and the landlord doesn't want kids there and evicts them because of that, that's going to be familial status discrimination. And then you can't evict someone based on their disability or handicap. Uh, that is handicap uh, or disability under the Fair Housing Act is going to be a physical or mental impairment, which substantially limits one or more of an individual's major life activities. The other thing I'll say about fair housing is it's also going to be illegal to evict someone in retaliation for trying to assert their fair housing rights. So if somebody makes, for example, a reasonable accommodation request to have some aspect of their disability accommodated, like they want a waiver of a no pets provision to allow themselves to have an assistance animal, or they want a reasonable modification, which would be like a grab bars installed in the shower or a wheelchair ramp. And the landlord doesn't want to do that, decides that he would rather just evict them instead. That's going to be illegal retaliation based on that individual's disability. The other way we see retaliation is retaliation for making some type of fair housing complaint. So if the tenant makes a fair housing complaint with HUD alleging, for example, sexual harassment or race discrimination, and the landlord then takes action to evict them because of that, that is going to be housing discrimination. And the tenant will have an affirmative claim under the Fair Housing Act, and they will also have a good defense to the unlawful detainer case. And I will say the unlawful detainer cases that we have taken all the way to a jury trial deal with these issues primarily. Forcible entry and detainer. So in the last few minutes left, I'm just going to talk about the other half of the unlawful detainer statute, the forcible entry half. Forcible entry is going to be when the landlord does something improper to forcibly dispossess a tenant without a court order. So the statute says person shall be guilty of forcible entry and detainer within the meaning of this subchapter if any one of these five things are true. And one of them is they enter into or upon any lands, tenements, or other possessions and detain and hold them without right or claim to title. They enter by breaking open the doors or windows or other parts of the house, whether the person is in it or not. Threats to kill, maim, or beat the party in possession, or use words, actions that have a natural tendency to excite fear or apprehension of danger. We have had tenants evicted at gunpoint. That violates this provision there. That's a forcible entry. Put out of doors or carry away the goods of the party in possession. So that's where landlord simply comes in and takes away the person's stuff. And then trying to frighten someone into leaving is going to be forcible entry as well. Examples that we've seen of forcible entry by a landlord or property owner: changing the locks on a residence or gate. So that's the landlord without a court order, simply going and changing the locks or boarding up the door or anything like that. Removing or trashing a tenant's belongings out of the rented residence. So just going in, throwing all the stuff out in the front yard and letting it get rained on while the tenant's at work or somewhere else, for example. That's going to be forcible entry. Removing exterior doors and windows. We've seen that one. I know one time I had a case where it was actually out of Greene County. The landlord just came and removed the tenant's front door, and really difficult to live in a house that doesn't have a front door on it. And when I called the landlord on it, he said that the front door was being repaired and had been being repaired for the last 2 weeks, which didn't make a whole lot of sense to me. So removing doors and windows, going to be an example of forcible entry. One we see all the time is cutting utility services. So that's either telling the utility company to turn off services to the tenant, turning off their water, turning off their electricity, or simply trying to mess with the utility boxes. We've seen that, cutting wires, that type of thing. Destroying or removing meters, just like what I was talking about. And then threats of violence. Gorman v. Ratliff is your Arkansas Supreme Court case that deals with forcible entry and detainer. That case involved a tenant who fell behind on the rent. Landlord asked them to vacate before the tenants could leave, and while they weren't home, the landlord entered onto the leased premises, removed all their belongings. And the issue here was that the lease specifically authorized that. So the lease said that if the landlord deemed the tenant to be in non-compliance, then the landlord at his option could enter onto the leased premises and retake possession. And we still see that language in leases today. Not a lot of leases, but it does come up every once in a while. This is the exact fact pattern that was dealt with in Gorman v. Ratliff. And what the Arkansas Supreme Court said is that unlawful detainer is the remedy for a breach of the lease where a landlord wants a tenant to be dispossessed. Landlord has a remedy given to him by that statute and must use it. The unlawful detainer statute, the protections in there cannot be waived by the tenant. So any lease that authorizes self-help is going to be invalid. And you see the specific language from the case there. No entry by a landlord on the property occupied by another is given except by first resorting to legal process. Accordingly, self-help action is prohibited. That is the law in Arkansas. You cannot do any of those things we talked about. That is going to be considered an illegal self-help eviction. And at that point, the tenant can sue the landlord for forcible entry and detainer and obtain damages as well as get possession of the property back if they have been dispossessed. Forcible entry, how does it work? Tenant files a complaint, makes allegations. They're typically going to ask for a temporary restraining order to put them back in possession of the property. And then they can also get damages for being dispossessed. Like I said, that's going to be, it could be moving expenses, it could be temporary housing expenses, that type of thing. They're allowed to get back. Additional claims that tenants who've been subject to this can make against their landlord. It says outrage there, but I'll say outrage and other tort claims. If the conduct is bad enough, it can certainly rise to the level of various intentional torts. Certainly threats of harm can trigger assault. If there's any contact, then battery. Outrage is more kind of a catch-all tort, but there are tort claims that the tenant can bring. Breach of the covenant of quiet enjoyment, that is recognized in Arkansas. That is the idea that if you lease a property from someone, you should be able to use and enjoy that property without unreasonable interference. Conversion is a tort claim for wrongfully dispossessing personal property. So if for example, the landlord throws all the tenant's possessions away, tenant will have a claim for conversion. Unjust enrichment, also potential claim there, and breach of contract, obviously. All right. So that's the presentation. Happy to take any questions here in the last 10 minutes that we've got.
Just to address the questions in the chat that have come up throughout the presentation. I think the question on attorney's fees was answered. But we did have another question that said, is a request for payment plan, actually, excuse me, that's a later question. I skipped one. And then unlawful detainer, what are a landlord's options if property is locked up in the unit following the lockout? I assume that means eviction. Tenant never comes to collect the property, but landlord does not want to proceed to a final trial for damages. I assume is what they mean.
I mean, what I've seen done that I think works pretty well in that case is to simply send the tenant a letter giving them a certain amount of time to pick up the property and letting them know that if they don't pick up the property within that certain amount of time, then it's going to be considered abandoned. And at that point, I think the landlord's on pretty safe grounds to dispose of it.
And then we had a couple of questions about reasonable accommodations.
Sure.
One was can just a general request, can we further discuss clarification of ADA service animals? So I'm not sure exactly what that question is asking, but maybe we can just kind of go over assistance animals.
Yeah, so the Fair Housing Act, which is the federal law and the state law, state and federal Fair Housing Act, which cover housing discrimination, protect individuals with disabilities from discrimination. They have a few special provisions set out in that law. One of those special provisions allows an individual with a disability to request from their housing provider a reasonable accommodation. A reasonable accommodation is a change in a rule, policy, or procedure which allows that individual with a disability to better use and enjoy their housing. And reasonable accommodation can be a lot of things. It can be a dedicated parking spot for somebody with a mobility disability. It could be payment arrangement in certain cases if a disability is causing non-payment. There are a lot of different reasonable accommodations, but one of the most common ones is going to be a waiver of a no pets policy or some limitation on pets to allow an individual with a disability to have an assistance animal in their home. And an assistance animal is going to be an animal that provides some benefit for an individual with a disability. And that could be something you would traditionally think of as a service animal or an emotional support animal. Those are distinctions made under other civil rights laws like the Americans with Disabilities Act. There's no distinction under the Fair Housing Act. If a animal is something that would help someone with their disability, whether that be because it provides a service like a seeing eye dog or whether it just provides emotional support, then the individual is allowed to keep that animal, provided that they can show proper verification for that. And verification can take many forms. Typically, that's going to be a letter from a doctor or other health provider stating the need for the animal, but it could also be a medical record. It could be a letter from some other third party who would know about the individual and their need for that animal. Hopefully that answered that.
And then another question related to reasonable accommodations was is a request for a payment plan to catch up on late rent and the dismissal of an unlawful detainer considered a request valid reasonable accommodation.
I mean, it's hard to say specifically. Any reasonable accommodation is going to have to be necessary and reasonable in order to be a valid reasonable accommodation request. So the individual is going to have to state, or going to have to show that they have a disability, which is a physical or mental impairment, which substantially limits one or more of their major life activities. And they're going to have to show a legal nexus between that reasonable accommodation request and their disability. And if they can do that, then the landlord will have an opportunity to assess whether it's reasonable or not. And it's going to be reasonable unless it's going to be an undue financial or administrative burden. And there's legal definitions for that. Or it's going to be a fundamental alteration in services provided. So it's very similar to like an employment law reasonable accommodation analysis.
And then Megan listed out some questions that she had from the poll. One was, does the provision of the CARES Act requiring a 30-day notice to quit prior to eviction remain intact for qualifying properties, i.e. subsidized housing?
So far, it does, but there is some law floating through Congress now to repeal that 30-day notice requirement. So I'm not exactly sure the status of that. I don't know. Jenny, do you know it?
No, I'm not sure.
Yeah, so as far as I know, there was no sunset provision in that requirement in the CARES Act that would automatically trigger, but right now there is a push by Congress to undo that.
Second question was, should an eviction complaint name occupants who are not on the lease?
I mean, probably if they're known to be there, a lot of landlords' attorneys will just name the leaseholder and any other occupants. But I would probably only do it if there was somebody there that you knew about.
And then third question, requirements of notice to quit vacate, 3 days or 30 days for housing assistance, habitability defenses.
So wait, say that one again. I didn't quite understand.
Yeah, I'm not sure. It asks about the requirements of notice to quit, vacate, and then there's a dash and it says 3 days or 30 days for housing assistance. And then says separate sentence habitability defenses. Okay, so Paige said those were two different questions. So I think we can break that up. 3 days or 30 days notice required
Yep.
for housing assistance.
So it's 3 days for non-payment of rent under the unlawful detainer statute. That's very clear. 30 days is typically how you terminate a month-to-month holdover contract. Uh, then, if it's some other breach of the lease, then it's going to have that 14-day notice requirement under the Arkansas Residential Landlord Tenant Act that has the permissive language in it that we went over. And then the other thing to know there is if it's subsidized housing and there's some federal regulatory scheme, occasionally those will have specific notice requirements like the CARES Act. But even in the absence of the CARES Act, for example, public housing has a 14-day notice provision to terminate a lease for non-payment of rent. So if you are dealing with subsidized housing, know your regs.
And then I think as a separate question, some participants were wondering about habitability defenses.
Habitability defenses to an eviction. You're not really going to be defenses necessarily. So if you say, okay, the classic example is somebody doesn't pay their rent and they say, well, I haven't paid my rent because some issue with the property, the floor is falling in, the roof's collapsing, whatever. There's not really a way to defend an eviction based on that. There is a new somewhat of a habitability law that was passed that allows tenants to break a lease in certain circumstances if the habitability situation is bad and if they follow a statutory procedure, but it's not really going to operate as a defense to an eviction case.
And then we had a question, can you recommend sources for sample lease agreements?
Not really. Your local landlord association, I would say, would probably be the best bet.
Okay, and then we had a scenario, Tracy Haggins. Section 8 tenant, sheriff deputy accompanied the property manager to change the locks, but never received a 30-day notice to vacate or any letter from the housing authority regarding eviction or writ of possession. Was locked out for 3 hours. The property manager then provided a key for the new lock. Now they're demanding payment that is not owed by April 15th, or else the
Yeah,
property.
I would say this one's a little specific to probably answer in a forum like this, which gives me an opportunity to plug our eviction defense program that we have. If you've got specific questions about your particular situation, then you are welcome to give us a call at our on our helpline, which is 1-800 9 Law Aid, and we'll help you out. We've got some specific. We've got a specific program now where we are doing a lot of eviction defense. It's called our Eviction Protection Grant Program. We've got attorneys now just focused on protection defense statewide, and we are happy to take your calls and try to help you out with eviction if you need that.
And I think that Ms. Smith's question is probably also best reserved for our helpline. It just gives us a lot more time as attorneys to talk to you and get more information that we need to give thorough legal advice. I think that was all the questions that I spotted. If I missed one, please speak up.
Yeah, that looks like all of them. Thank you, Jenny. And thank you, Jason. That was really great. And thank you for taking the time to do all of this for us. So I noticed there are a couple here who joined by phone call. If you did, can you please email me with your phone number so I can get you your attendance form? And to everybody else, I will be sending you a follow-up email shortly here with the email that you used to join this session. So it'll include the attendance form, our upcoming CLEs, and a copy of Jason's PowerPoint presentation. If you have any other additional questions for Jason, I'll get contact info from him where he would like you to contact for additional questions. I'll include that helpline. So thank you all for joining us today, and we hope to see you at our next CLE. And Jason, do you have anything you'd like to add?
No. Thank you guys for having me. Hope I didn't bore everyone too much during their lunch break.
No. Thank you again, and thank you, Jenny. Y'all have a good one.
Absolutely. Thanks so much.
Thank you.